The first case study to talk about tonight happened in Bernie Township, Ohio. Fire Chief Dennis was demoted from fire chief to lieutenant by a vote from the Township's Board of Trustees. This decision was made after the state fire marshal had notified the trustee board that he had not been receiving his NFIRS reports from any of the fires in the township, and to which they investigated and found that he had not submitted any of these reports. And seeing how necessary these reports are, the trustee board held a vote on what to do, and on a 2-1 decision, he was demoted from fire chief. After being demoted, Dennis then filed an appeal to the Ohio Court of Common Pleas and a lawsuit against the township trustee board alleging violations of his constitutional rights, to which the township pushed the case from the state level to a federal level. The court found that the trustees board removed the fire chief properly and that they followed all the due processes of the fact-finding and all other processes to demote him. The appellant made several claims that he had no evidence for or could back his point. Most of them were at Trustee Carmichael and his involvement in the investigation and the fact-finding, and that he did not follow due process. The court found that he did. He had no evidence for this claim. He also alleged that Trustee Bailey had other motivations to remove him from this position, but again, the court couldn't find any malicious intent, found that the only grounds that he voted for his demotion were on the grounds of him not completing the forms. Lessons we can learn from this is that if you have any forms of reports to file, doing them in a timely manner in which your job expects you to should be done, or you'll be fired or demoted without proper evidence to back up your claim that whoever is firing or demoting you, giving you any disciplinary actions, did it incorrectly, then you cannot go after them for not, because you can't prove that they did it wrong at all. The newsletter case study was also out of Ohio. Paramedic Plunk had performed a blood draw on a suspected DUI driver who caused an accident and was detained by the police. They refused any medical attention, and they refused a field sobriety test. The police had gotten a court-approved search and seizure warrant to get a blood test to test for the blood alcohol levels. Paramedic Plunk then drew the blood of the patient, and he received verbal consent to do so from the suspect, and believed that he was acting in the right because he had consent from the suspect and he had a warrant issuing him to do it. The problem was that he never reached out to his medical director and didn't know that the township he works in did not allow paramedics to do blood drawings, and he did not ask the medical director permission. This angered the medical director because he felt like the paramedic was acting in a way to harm his medical license on purpose. One of the things that they used to fire Paramedic Plunk was that he never filed the report of the blood drawing, but the way they explained it, the way that Paramedic Plunk explained it was that he wasn't sure if he was supposed to because there was a warrant for it, and so he emailed his supervisor asking which way to properly file it. But by that time, there was already a hearing on what to do with him. There were several miscommunications that led to Plunk losing his job in Chester County, along with the acting medical director making several claims to Plunk's other job in another county that were found to be false. When it came to the disciplinary hearing, Plunk was never able to give his side of the story, nor was he told every reason that he was fired. He was just told about the blood drawing. None of these claims that the medical director had said to the other county or other township were brought up at all. In the end, the court ruled that the plaintiff, Plunk, was not fully represented in the disciplinary hearing. He was not able to give his side of the story. The decision that the fire chief and the medical director had made without any due process to fire him did not follow the standard practices. The defendant also didn't give all the reasons why he was fired. Like I said, only gave him the blood drawing was an issue, but it was not the only issue. What we can learn from this is when it comes to the due process of disciplinary actions, whether that would mean the termination or reprimand, all of the information, i.e. the reasons why said employee is getting fired, needs to be shared with them so they're given a fair chance to make up for those mistakes if they have any reasonings or can't explain them. If not, these things will happen. This same exact scenario could happen in court where the employee takes them to court because they didn't follow the right due process. The current event case study that I did was a firefighter in East Hampton was charged with sexual misconduct and fired from his job as it was discovered that he secretly hid cameras recording both audio and video in the women's locker rooms of the firehouse. At first he claimed not guilty of the accusations, but later did admit that he placed the cameras there. In this case, he was fired for unlawful wiretapping and recording, which is never allowed in any situation, especially with sexual implications. This disciplinary action that was taken by the leadership of the firehouse was correct, as breaking of the law or any code of conduct or any employee rules are met with immediate termination. What we learn from this is it's an example of what not to do. Never would an act like this be okay in any work environment, especially not one where you're supposed to live together and work as a team. And anytime something like this happens, it will always be met with the same consequences.